me? I never sit. You know that. Vicky?
My name is Henry Lee, and I am the Director of the Environment and Natural Resource Program here at the Kennedy School of Government, and I would like to welcome you to tonight's forum event. In preparing for this, I was reading a number of periodicals, and I finally found a quote from Representative Young of Alaska, who identified the problem with the environmental regulations in America. And he said, the problem with environmental regulation is the product of self-centered, waffle-stomping, Harvard-graduating idiots. So we are the problem. Tonight, we will be discussing a number of questions that will determine the future course of environmental regulation in the United States. Starting with the Environmental Policy Act of 1969, the United States embarked on a 25-year program of cleaning up its air, its water, and providing a healthier and cleaner environment for all Americans. Thousands of acres of wetlands have been protected, reforestation rates have exceeded almost everyone's predictions, and with the passage of the Alaska Lands Act and a series of wilderness and park bills in the 1970s and 80s, we have dramatically increased the number of acres under federal protection. America's record of environmental legislation has become a model for the rest of the world. This record was achieved in a remarkably bipartisan effort. In his environmental message to Congress in 1983, President Ronald Reagan, not renowned among environmentalists as one of their stalwarts, stated, "I believe that our nation has a God-given responsibility to preserve and protect our natural resource heritage. Our physical health, our social happiness, our economic well-being will be sustained only to the extent we act as stewards of our abundant resources." Today, the bipartisan consensus has become frayed. People are beginning to ask whether the means we have chosen to meet our environmental goals are either effective or efficient. They ask that in an era when the incomes of middle Americans are being squeezed, can we continue to ignore the costs of our environmental initiatives? And when, out of this concern and out of the political sea chain of last November, there has emerged a series of highly controversial bills that could dramatically change the course of environmental policy. Tonight's forum will discuss two of those bills. The first attempts to correct the alleged misallocation of resources that result from current approaches to risk analysis and regulation. There are several bills. All call for federal agencies to conduct risk assessments before promulgating major rules. This means the agency must determine how much of the substance people are exposed to, how much of the substance causes what type of harm, and what risk the substance poses in the way it is used now and will be used in the future. This risk assessment must also be used to develop a cost-benefit analysis. These analysis and assessments would be subject in most of the bills to judicial review. The second group of bills seeks to protect the rights of private property owners. Specifically, they require federal agencies to assess the impact of their actions on private property and to compensate the owners if that impact or taking exceeds a certain percentage of the value of the land. The House has limited these bills to the Endangered Species Act and the wetlands provisions of the Clean Water Act. The Senate, as of yet, has yet to limit it, and it is now still open to all areas. We are fortunate to have 4 eminently qualified speakers this evening. I am going to, at this moment, introduce each of the 4 and then allow them to speak. This will be followed by a question and answer period. Our first speaker is Fred Smith, who is the president and founder of the Competitive Enterprise Institute, a public interest group active in a wide range of economic and environmental policy issues. He is a frequent guest on many of the national news shows, and he is the author of Environmental Politics, Public Costs and Private Rewards, and he is a former employee of the Environmental Protection Agency. Our second speaker is J. Michael McCloskey, who is the chairman of the Sierra Club, a post he has held since 1985. He has been one of the major spokespersons in this country for the environmental movement for close to 25 years. He is now also serving as an adjunct professor of public policy at the School of Natural Resources and Environment at the University of Michigan. He is a Harvard graduate, and he is a lawyer. Our third speaker is Dr. Lynn Goldman, who is Assistant Administrator for Prevention, Pesticides, and Toxic Substances for the United States Environmental Protection Agency. She is a pediatrician and an epidemiologist. She is formerly the chief of the Division of Environmental Occupational Disease of the California Department of Health Services, and she received her MD from the University of California. Our fourth and final speaker is Paul Portney, who is the Vice President for Resources for the Future, an independent, nonpartisan research and education organization. He has been one of the leading intellectual forces in the environmental policy field for the last decade. He is formerly director of RFF Center for Risk Assessment, and he received his PhD from Northwestern in economics. I now turn over the microphone to Mr. Fred Smith.
I'm pleased to be here today because I think what we're seeing in these type forums is the final, at long last, we're getting serious about environmental policy, and I think it's a long time we do so. One of my friends from Northern Virginia teaches in grammar schools, and she was giving a little IQ test to one of the little students in her class, and she said, this is a real question on the IQ test, Johnny, why does oil float on water? And Johnny, well educated in ecological correctness, looked at her and said, well, ma'am, I guess it's because people just don't care anymore. We all care about the environment. It's time we engage our brains, and I think the challenge today is to discuss the background and the meaning of the substantive reforms that are now winning their way through Congress, the environmental features of the Contract with America. In my view, the period in American history that we're now going through is revolutionary. It marks a move away from the progressive ideology that has long dominated American policy, specifically environmental policy. The dominant paradigm has been that markets and other voluntary arrangements were fragile, delicate institutions that could and often did fail, that political solutions would readily be devised, and that such solutions would be dynamic, robust means of setting the world aright. The result has been the modern regulatory state, a vast and complex array of health, safety, environmental rules, rigidities, intended, so we are told, to make us healthier, safer, cleaner, with only slight infringements on our liberty. The results, I think you could argue that the first generation of environmental policy has done some good. We were addressing a handful of haystack-style problems. We had a handful of criteria, water pollutants, sewage in the rivers, raw smoke coming out of smokestacks. And in those areas, even crude, ham-handed regulatory means sometimes could and possibly did do some good. But we're well beyond that point now. We're now not dealing with haystack problems. We're dealing with needles in haystack problems, and I would argue in that case, regulatory means have increasingly proven inadequate to that task. What we're doing is not only weakening steadily our ability to privately address environmental issues, we're also seeing a massive array of problems, misprioritizations, we'll be talking about, I suspect, the calls, the micromanagement of our economy, heightened conflict, which is a serious area, I think. And generally, I think what we've seen in the November elections, in part, were a reaction against the regulatory, nanny regulatory state, and an interest in exploring alternative means, not of abandoning the environment, but finding something more creative than bureaucracy to address our concerns there. Americans care about environmental protection. They care about the Environmental Protection Agency only if it delivers, and increasingly it's not delivering very well. What I would like to do, since this is an intellectual forum, is before we get into the nuanced political aspects of this debate, to just touch upon the intellectual roots of what's going on in the contract, what's going on in the rethinking of the regulatory state. We're an activist think tank, and therefore, naturally, we think ideas have consequences, for good or for bad. And I'd like to touch upon the ideas of four people, three Nobel Prize economists and one prized political scientist, who've affected where we're going, I believe, on environmental policy. James Buchanan, a Nobel Prize winner for his work on what is now called public choice or rent theory, the realization that people don't become angels when they join the Environmental Protection Agency or government generally, that private self-interest does not disappear in the political regime, rather it often takes very perverse forms. It's sometimes harder to discipline self-interest. And works that actually, in this case, Sierra Club and we are both working on, the ethanol situation where Archer Daniel Midland, the only company in history, I think, that owns both the Republican and the Democratic Party, have managed to turn government moonshine into a way of life. My book, Environmental Politics, deals with that. Flow control, where we're balkanizing the ability of handling waste in our country, and a whole series of issues where special interests dominate the environmental politics. That's a serious problem, and it's something anyone who believes politics is the answer has to address. The work of Ronald Coase, another Nobel Prize winner, who has a lot of things to say, but essentially that institutions matter. It's not enough to say we care and we design policies. The institutions we create have a lot to do with what works, what incentives exist, and among those incentives, institutions, he argues, private property is one of the key ones, and I'll talk about that later. He also argues that if one looks at the history of environmental protection for the last several hundred years, one often finds that markets were sabotaged rather than failing. I'd like to read one quote from his article, The Problem of Social Cost. He's discussing situation after situation where political policies eroded the ability of private owners of their property to prevent pollution. And then he says, not surprisingly, most economists seem to be unaware of all this. When they are prevented from sleeping at night by the roar of jet planes overhead, publicly authorized and perhaps publicly operated, or unable to think or rest in the day because of the noise and vibration from passing trains, publicly authorized and perhaps publicly operated, find it difficult to breathe because of the odor from the local sewage farm, publicly authorized and perhaps publicly operated, and are unable to escape because their driveways are blocked by a road obstruction, without any doubt, publicly advised. Their nerves frayed and mental balance disturbed, they proceed to disclaim about the disadvantages of private industry and the need for government regulation. That kind of thinking, I think, is absent from almost all the debates. Markets fail, government will succeed has been a slogan, not a thoughtful process. Incidentally, there's a lot of work going on now by environmentalist groups, ourselves and so on. There's a book that just came out, Property Rights and the Defense of Nature by Environment Probe, which details a lot of the history of the sabotaging of private nuisance law and trespass law as a means of preventing pollution. Another person, Ludwig von Mises Friedrich Hayek, the Austrian economist, who basically pointed out that modern societies can't run by top-down centralized planning, that the economic problem is not utilizing this knowledge already acquired, blackboard economics, but rather it's finding ways of using the dispersed knowledge only available in a decentralized mode to bring about a public result that is better than could be done by any centralized manager. How do we, in effect, organize a modern society by decentralization, by private property, and so forth? Because if you look at EPA today, or environmental policy broadly, the major problem is not that we are doing wise things foolishly. It's that we're doing far too many foolish things. Radon, dioxin, shipping lead paint, pesticide residues, asbestos, chlorine, spotted owls, elephant ivory, golden cheek warblers, karst invertebrates. We seem to be trying to do everything, and in the process, we're not doing anything very well. Economic central planning has failed. Even Harvard, I think, knows that. Ecological central planning is failing even more dramatically. It's harder. Finally, let me touch on the work of Aaron Wildowski, who died a year ago, some of you know. Aaron was one of the great thinkers. Aaron would basically rail against what he referred to roughly as white hat regulators. I'm at EPA. I wear a white hat. I want to make the world safer, cleaner, healthier. You out in the rest of the world only care about money, bottom line results. Well, sometimes in this messy political world you prevail, but I stand for purity, beauty, the American way. In that kind of a morality play, the regulators often win when the economy's healthy, when the economy's in the tank. We delay the regulations until the process recovers, and then the regulatory bloodletting recommences. The real challenge to mankind is not how we regulate everything, but deciding when the risks of regulation are greater or less than the risk of not regulating. There are risks of new technologies, there are risks of process, but of course there are also risks of technological stagnation. The goal is to create societal institutions that balance the risk of going too fast into the future versus the risk of holding back too long, between going too fast, going too slow. Aaron's work, Searching for Safety, but Is It True, a book coming out in Harvard Press later this year, is an attempt, have now essentially underlined much of what's now going on in the risk reform features of the study. That's the intellectual background of the Contract with America. The first fruits of an election in which Americans, I believe, have made a U-turn on the road to serfdom. We have decided, I think, in America that the only good government is limited government. The challenge is to restore, strengthen America's individual abilities to address problems we all care about in a more meaningful way. The two contract themes that Hillary touched upon, property rights, the key elements of a rational environmental policy, a rejection of this land is your land, this land is my land, confusion. I mean, has anyone ever had a title search done in questions like that? Basically, land ownership is a way of putting people in a stewardship relationship to nature and allowing them to protect their part of the earth and then protecting it for the rest of us. When everyone owns everything, we're in the tragedy of the commons. We're in a situation where effectively we have great difficulty bringing our concern about nature to bear in a meaningful way. Good fences make good neighbors, if you've been following the New York Times controversy on this. But in this case, it's certainly true. If you look at the difference between the way the spotted owl is treated today and the way the wood duck was treated at the turn of the century, and we can talk about that in the question period, you find a difference between a set of institutions that encourage humans, people who cared about nature, to move aggressively as individuals to protect nature, and a set of institutions today, the Endangered Species Act, which encourage people to shoot, shovel, and shut up. Because if you find an endangered species on your property, you're at great risk of having no property left. Ecological privatization, ecological adoptions are going to be themes you're going to be hearing a lot about as we move beyond the fledgling steps in the contract to serious rethinking environmental policy. Trees can't have standing, but behind trees and aquifers and elephants and lots of other things can stand owners who by protecting their property, advance environmental policy for the rest of us. The risk reform area, essentially, when you strip aside all of the technicalities of the risk reform bills, you're basically talking about a common sense reform. You're talking about, some of us have been operated upon, or know doctors. When a doctor sits down to operate on an individual, the first thing he asks himself is he violating his Hippocratic oath, which is first do no harm. He doesn't do an elaborate cost-benefit analysis, but he or she basically looks at the situation and in their professional judgment decides that their intervention, their operation on the individual is likely to do more good than harm. They may be wrong, but they try to do their best in that judgment. If our regulatory doctors are going to operate on our economy, then shouldn't we ask that they have a regulatory Hippocratic oath? And that's really what's going on in this situation. Risk analysis, super mandates, petitioning, and above all, judicial review are key elements of that, but those are the sinews of a structure which basically says, don't regulate if you're going to harm the economy. You can criticize a lot of the details, and I suspect we will in this, but remember, we're dealing with a battle plan that was drawn up when it looked like the environmental movement and the regulatory establishment were 1,000-pound gorillas. The next generation of reforms will be much more nuanced, and I think will improve dramatically on these first steps. Americans care about clean air. They're not so sure about the Clean Air Act. They care about endangered species. It's not so clear they care about the Endangered Species Act. The challenge, I think, is to transcend the regulatory state, to find ways of moving beyond the bureaucratic approach to everything we've been adopting to date, and to find creative ways of taking our care, our concern about the environment in which we live, and translating it into meaningful, sensible, effective policies. That's the least we can ask if we really are serious about environmental policy.
Thank you. Michael?
I'm going to try to get down to brass tacks and talk about these two measures. If I have time, I'll address the takings legislation. The legislation that we're talking about here on risk and cost benefit is that passed by the House of Representatives, and I think particularly embodied in the Dole bill in the Senate. The impact of these proposals would be greater than the existing executive orders that have dealt with these problems, because they kick in at a lower threshold, $25 million or $50 million rather than $100 million. And the harm they would do would be much greater. They can displace existing health-based standards and undermine protection of public health unless there's a specific provision in existing statutes against cost-based rules. It's important to recognize that these provisions deal with standards as well as control requirements. Under them, cost-benefit determinations would dictate the standards, not public health studies. What is needed to protect public health will be fuzzed up under trade-offs with economics. They're oriented toward having us learn to live with toxics in our environment. And the provisions dealing with risk, they narrow the ambit of perceived risk through various one-sided criteria. They'll force us to live with more toxics and more pollutants. They represent a turning away from the ideal of pollution prevention. They rationalize living with chronic pollution. They put emphasis on risk assessment at the wrong time. It should be done when risky materials are introduced into our environment by manufacturers, not when the government tries to do something about the resulting problems. And they jeopardize the survival of many of our pollution control laws, thus denying the public the protection it has come to expect. If they become law, these measures will create massive uncertainty about what standards industry will have to comply with. By subjecting existing regulations to survival by new cost-benefit determinations, it'll leave it completely unclear about how much of the existing body of law will survive or be invalidated. This is the so-called super mandate, which reaches back to subject existing regulations to these new procedural requirements, and substantive ones too. They invite a huge amount of litigation to challenge existing standards. The Dole bill does this in the Senate. They provide new grounds for lawsuits challenging regulations for alleged failures to meet all of the new procedural requirements. Litigation may even be in order before a final regulation is even promulgated. They erect new bureaucratic processes which will be slow, cumbersome, and costly. The House bill sets up a 23-step process for approvals of new or revised regulations. Issuance of new regulations will be excessively delayed. They will engender paralysis by analysis. Regulations will face endless layers of studies. The EPA estimates that it will need 1,000 more new employees to be able to comply. It's been estimated that it will cost them $220 million each year to be able to work under this system. The standards for decision-making also will be skewed. Cost-benefit determinations or studies, I should say, should inform decision-making, not dominate it nor drive it. They should not dictate decisions. Such studies have severe limitations. Benefits are often understated, and the costs are often overstated. Many benefits cannot be reliably quantified. Such studies will tend to rule out many needed regulations. Cost-benefit tools are no substitute for discerning judgment, which takes into account both things which can and cannot be quantified, and that includes moral obligations. Quantified data are simply not available on many critical questions, on many chemicals, especially on problems of low doses and on non-cancer types of risk. The bills would enshrine bad science. They would freeze the approach to risk assessment by statutory standards rather than letting it evolve over time. Risk assessment is poorly equipped to address many problems such as birth defects, neurological disorders, immunological system damage, and so forth. The legislation is simply overly prescriptive. The actual way in which public health operates as a science is fundamentally misunderstood. Its practitioners will be forced into the mold of economic tools where everything must be prematurely quantified or not given any weight. The appropriate use of the precautionary principle, which is recognized in international practice to deal with uncertainty, is really disregarded in these bills. This legislation is thoroughly ill-considered. It involves a major rollback in our laws to control pollution, and it would do so in a way that creates massive uncertainty for the business community. It's bad business for everyone involved. Now, if I have any time left, let me turn attention to the takings legislation. This set of proposals would create a massive new entitlement program. It could set precedents which could end up costing the federal government billions of dollars. One estimate for the wetlands program alone was $10 to $15 billion. Agencies will be inhibited from ever issuing restrictions on property because of fear of depleting their budgets. It'll be very difficult for them to make reliable estimates of the liability that would be created for the federal government. Progress under programs like the Endangered Species Act would be undermined. That program is making progress. 230 species have already been rescued from the brink of oblivion, and their protection programs under that act do take economic factors into account in designating critical habitat. It's important to recognize that wildlife is a common property which belongs to the states. It is not unreasonable for the government to try to guard against the disappearance of the genetic codes for the perpetuation of its property. It's appropriate for the owners of land to bear restrictions to protect the property of the government from extinction. When landowners contribute to the extirpation of species, they are taking government property in its entirety. And this line of reasoning applies to western river flows as well, which are covered under the bills. It also covers wetlands, and wetland protection can involve protection of nearby properties from flooding. Wetlands can reduce pollution and improve water quality for downstream economic uses. Owners can benefit from wetland protection. The government should not be forced to pay developers not to increase the risks of floods nor of pollution. The provisions of the Constitution which deal with takings are working and are workable. The courts have interpreted these provisions to mean that compensation is required whenever the owner is not left with any economic use of his property as a result of regulation. Historically, it has not been required for most land use controls. And that's what we're talking about here. The Congress would be well advised to let the Supreme Court render its decision in the Sweet Home case to see whether any real taking has occurred under the Endangered Species Act. It is sound policy, public policy, to allow limited reductions in property values without requiring compensation. Land use controls are designed to promote the overall public welfare. Their net effect is generally to enhance property values. Trying to weigh degrees of loss and gain to each property owner will impose impossible burdens and break down the system. More bureaucracy and confusion will be created. A better approach for legislating to deal with the complaints under the Endangered Species Act is to provide financial incentives to owners to induce them to undertake actions to aid in the recovery of endangered species. The environmental movement will support such legislation. And that approach already applies to wetlands under the Farm Bill, and it might well be extended on a limited basis to other wetlands too. In concluding, the takings proposal passed by the House is bad public policy, is unnecessary, and in the end will hurt property values.
Thank you. Lynn?
Good afternoon, and thanks for inviting me to be with you here today. I think this is a particularly appropriate time for this forum to be held. It's 25 years since the first Earth Day and almost 25 years since the formation of the EPA. And I think it's important to look back at the sentiments behind the original Earth Day. The environment really was broken 25 years ago. In many of our communities, the air was difficult to breathe. There were uncontrolled discharges of all kinds of contaminants to water. Much of our water was not fishable or swimmable. Our drinking water in many communities was threatened. The laws passed by Congress and the regulations that were established by federal, state, and local government have had a number of positive effects. The environment is cleaner today. Our air and water are cleaner. Our water is safer to drink. Our communities are safer. These are remarkable achievements. Still, we have many environmental problems that remain today and for which solutions are not simple. And I don't think that it takes a rocket scientist to realize that with continued development and continued property population growth, that we will need to continue to find new solutions for our environment. But are we making the best use of our resources for environmental protection? Are we using the best tools that are available to us in the most appropriate manner? Are the command and control measures that we used in the past adequate for today's problems? Our toolkit today has been supplemented with new tools: performance-based standards, pollution prevention, right to know, new scientific information that we did not have 25 years ago. We need to be able to incorporate the use of those tools. The public speaks with many voices in environmental protection. There is a question we need to ask: can the public play a stronger role in protecting health and the environment? Can states and local communities play a stronger role? The Clinton administration has emphasized participation of all of the public, including consumer and environmental groups, community groups, industry, and government at all levels in creating new environmental strategies. We have also championed reform both in legislation and in regulations. In fact, during the last Congress, many were in a state of disbelief at the number of environmental laws that we proposed to change. We worked to change the Superfund law, the Clean Water Act, the Safe Drinking Water Act, and our food safety legislation. None of those reforms were enacted, but obviously those are still matters that need to be attended to. President Clinton has also directed all agencies to review regulations to remove and modify obsolete or unnecessarily burdensome requirements. And the EPA has taken a number of steps to improve our science base for all of the decisions that we make. As the President has said, the goal is a government that responds to people and not to bureaucracy. In terms of the issues at hand, the legislative provisions that are a part of the contract with America, there are a number of specific problems that need to be considered. Some of the proposals sound good in theory. Proposals to require risk assessments and cost-benefit analyses for decisions. Proposals to increase judicial review of agency actions. Creation of mechanisms for citizens and others to petition their government. And increasing the adherence of the agencies in a more strict way to the letter of the law. These kinds of concepts, if used in a constructive manner, could lead to improvements in the process. But unfortunately, the current provisions that are under consideration would not improve our process. In fact, we believe they would actually impede our efforts to become a more flexible, efficient, and scientifically advanced government. For example, risk assessment and cost-benefit analyses are indispensable tools for crafting common sense regulations. The EPA has used these tools for really all of our existence and have worked very hard to improve the methodological basis for these tools. But this legislation would not do that. In fact, this legislation, rather than improving the use of these tools, would tend to rigidify their use, rather than decreasing bureaucracy, would tend to increase the bureaucracy in government. It is very difficult to quantify health and environmental benefits, and this is one of the reasons we are so concerned about the sole use of cost-benefit analysis for making decisions, which has been proposed by many. What about other factors that we need to consider, such as equity, such as who is paying and who is benefiting from the actions that we are taking, such as the factors that are very difficult to quantify. Many health effects are hard to quantify. Effects for the environment are difficult to quantify. Will these benefits fall off of the table because we don't have a way to assign a careful dollar value to them? And I should say that particularly risk assessment has been soundly criticized by many as a tool that often has large margins of error, is very dependent on assumptions, and can be riddled with value judgments. Oddly enough, it is those who have been most critical of the risk assessment tool who have pushed the use of risk assessment and cost-benefit analysis as being the sole means for making decisions by the government. I think it is also should be realized that these laws would modify all of our health, safety, and environmental statutes, not just selected ones that people are concerned about. And it's a very broad brush approach that I think people really need to question. Do the provisions that make sense for EPA make sense for transportation, for consumer products, for food and drugs? That question needs to be asked. Some of the specific provisions that are of concern, the look-back provisions that would require every regulation to sunset unless it is reviewed every 5 to 7 years. Do people seriously intend that every single regulation needs a review every 5 years? 20 years ago, children used to suffocate by locking themselves inside abandoned refrigerators. And the government passed a regulation that required that refrigerators can be opened from the inside. Is that a regulation that we need to waste our time reviewing and doing complex analyses for every 5 years? The judicial review provisions, in particular, would create 100 new opportunities to challenge measures, taking the government to court at every turn when affected parties did not like a decision. Litigation gridlock would be an inevitable consequence. 6 new petition processes would be created, which would cause many, many delays in being able to enact any new regulation, and in fact, would undermine existing standards. There are new defenses to enforcement actions that would eliminate agencies' interpretations of rules unless specifically communicated to defendants, which we think goes too far in allowing lawbreakers to block enforcement of environmental laws. Specific bills are proposed to be amended, but from one side only. CERCLA and RCRA amendments require extensive new analyses and allow petitions to reopen cleanups that are already in process. No provisions are present to provide communities that need to be restored with new rights or new capabilities to make their communities cleaner. The Delaney Clause in our pesticide law is repealed without addressing the need for food safety reform. The Chevron Supreme Court decision is reversed, stopping agencies from being able to interpret their own statutes as we attempt to carry out those statutes. But the problems go beyond these individual procedures. They are, first, these laws are a very broad scope. They don't just affect rules and regulations, but even guidelines and interpretations that government agencies must do. Second, the cost-benefit analysis and risk assessment provisions are very extensive, and we shouldn't kid ourselves. With judicial review being required at every turn, what will inevitably result is a slavish adherence to a very precise way of doing these analyses in every instance, irregardless of the magnitude of the decision that is being made. Third, the extensive new petition rights with deadlines in judicial review would swamp agencies with petitions. Fourth, and contrary to what many will tell you, these provisions directly or indirectly modify existing statutory standards, providing an opportunity to roll back the protections that we enjoy today. And finally, all of the new litigation would carry with it an enormous cost. And I'm not just talking about the cost to the agency of defending these suits, but I'm also talking about the opportunity costs, the opportunities that will be missed to improve how we carry out environmental protection in the future and to address new health and environmental issues as they arise. This is not common sense, and I would say this is actually the moral equivalent of doctors sitting around debating what to do about taking care of a patient while the patient dies. With President Clinton, we at EPA understand that this is not what the American people want or expect from their government. The people expect us to put their interests, their health, their communities first. They do not expect what we've seen on the Hill, and that is the regulated community, business groups, and lobbyists writing these bills that would change these standards. We can support real reform, but we cannot support rollback. We must move forward as we find ways to make environmental protection more flexible, more cost-effective, and more based on good science without sacrificing public health and environmental protection. Thank you.
Thank you very much. We see we have an emerging consensus for Paul to try to bring this together. Paul?
Okay. Well, fellow waffle-stomping idiots, I'm delighted to be here, and despite the seating arrangement tonight, I find myself in a very conventional position of falling between the views of the panelists that you've heard so far. To be more specific, I guess I disagree sharply with both Lynn and Mike McCloskey concerning the consequences and effects of requiring federal regulatory agencies to take cost into account in setting standards and to certify or ascertain that prospective regulations justify and bear a reasonable relationship to, if I can quote language from the House bill, the cost associated with those regulations. As I'll explain in just a minute, I don't think there's anything wrong with that at all, and I think that there's a chance that this would substantially improve the quality of the regulation that we see out of Washington. By the same token, I disagree in some cases quite sharply with Republican senators and congressmen, and possibly my fellow panelist tonight, Fred Smith, about the possible consequences of expansive judicial review of agency rulemaking. And I also have considerable concerns about look-back provisions, and I'll explain what I mean by these terms in just a second, that have the potential of forcing any regulatory agency, and particularly the EPA, to have to revisit all of the rules and regulations that they've put in place for 25 years at one time. Let me now try to be a bit more specific. And in doing so, and in the spirit of an educational institution, let me try to be just a little bit didactic here. All of my fellow panelists have thrown around three sets of terms, and these are the following, and they are, in my judgment and apparently the judgment of my fellow panelists, the three most important provisions associated with the regulatory reform legislation that is before the House, or that's passed the House and is before the Senate now. The three things that make a big difference in these bills, folks, are the following. First is the extent to which regulatory agencies will be required to take costs into account in setting standards, where in the past, and pay careful attention to this, they have been prohibited under judicial interpretation from even considering costs in setting important national standards, and the extent to which regulatory agencies will be required to, in qualitative terms, certify that the benefits of the regulation exceed the costs. You've heard the term super mandate thrown around. If I can just try to clarify this for you briefly, super mandate legislation is legislation that would simultaneously modify and override provisions in the Clean Air Act, the Clean Water Act, the Safe Drinking Water Act, the Occupational Safety and Health Act, the Consumer Product Safety Act. It would override those provisions which currently prohibit regulators from taking cost into account. So in a sense, it would simultaneously amend a number of federal regulatory statutes. And I'll come back to this in just a second. The second issue that we should care greatly about is the expansiveness of judicial review of agency rulemakings that the various pieces of regulatory reform legislation would require. And then the final thing to care about is whether or not the regulatory reform legislation would apply prospectively, that is, only to new rules and regulations written after the time the regulatory reform legislation would pass, or whether or not there would be provisions that would force the agency to go back retrospectively and visit existing rules and regulations under a new set of benefit cost criteria, so that the agency would not only have to apply benefit cost analysis in a forward-looking way, but would also have to do so to rules and regulations on the books. For what it's worth, I want to give you my views on this and explain why my views probably differ from those of my fellow panelists. Concerning the requirement that the agencies would, in the future, have to take cost into account where they're currently prohibited from doing so, I think this is a damn good idea, to put it quite bluntly, if I may. And EPA and to some extent Lynn tonight have used two arguments against this. Argument number one is we're already doing this already, and argument number two is this is the end of environmental regulation as we know it. Now, notwithstanding the fact those two defenses, Lynn didn't use them both tonight, but other people from EPA have, notwithstanding the fact that they're mutually inconsistent, I take issue with both of them. First of all, if EPA is already doing all of this risk assessment and benefit cost analysis already, what's wrong with passing a law telling them to go ahead and do it? I don't see anything wrong with that. If they're doing this stuff, then it shouldn't make a big difference to require them to do it in the same language in some cases as the presidential executive order that Bill Clinton issued now requires them to do. The second defense that one often hears is, gee, if this benefit cost analysis stuff passes, this will undo and wipe off the books all of the rules and regulations we've written for 25 years. Now, does this mean that the people at EPA believe that none of the rules and regulations on the book would pass even a qualitative, non-quantitative benefit cost test? I don't think that's true. I've done benefit cost analyses that show that a number of federal rules and regulations pass benefit cost test with flying colors, and I think any number of existing and prospective EPA regulations could be shown to pass a benefit cost test if this legislation passes. Let me turn to the judicial review provisions, because there's an interesting inconsistency here, but it pertains to the Republican position on this. For many years, Republicans in Congress have said that one problem with environmental regulation is that we get too much congressional micromanagement by 25-year-old Hill staff aides who've never worked a decent job in their life. And yet these very same people now want to set up a system that will result in judicial micromanagement by 25-year-old law clerks working for courts of appeals. And my sense is these people are unlikely to have worked in chemical plants, iron stamping mills, or other things like that, just like the congressional micromanagers that the conservatives have derided in the past. So the concern here is how can we fashion judicial review that will both enable us from time to time to catch and filter out a silly decision that a federal regulatory agency makes without having the courts second guess every doggone decision that a federal regulator makes. One way to do this is to narrow the scope of judicial review to the procedural requirements that agencies do risk assessments, do benefit cost analyses, and then have both carefully peer reviewed, and limit the judicial review to whether or not the agency did that without enabling the courts to say, gee, they used the wrong dollar value for one case of asthma prevented. They should have used $3.86 rather than $32.59. That's not the kind of decision making that I want courts to make. Those are the kinds of decisions that I think Lynn Goldman and her colleagues at EPA and her and their counterparts at other federal regulatory agencies ought to be making. And expansive judicial review is going to make things worse rather than better. Let me turn to the third of these three provisions, the so-called look-back provision. Here I have mixed reactions. And you should know that the bills before the Senate now take very different approaches toward this. The House bill has no look-back provisions whatsoever and would apply only prospectively. Senate Bill 291, sponsored by Senator Roth, says, yes, the agency would have to apply the new benefit cost criteria to existing regulations, but over a 10 to 15-year period, and only applying that to major regulations. That's to say regulations that would have a $100 million per year impact or more on the economy. The much more draconian look-back provisions, in my opinion, are those in Senator Dole's bill, S-343, which would establish a petition measure whereby any citizen could, once the regulatory reform bill had passed, petition any regulatory agency to look back and review any existing regulation, and in principle at least every existing regulation. The agency then would have 90 days to determine whether or not they were going to open up the old rules. If they decided not to, and they certainly don't have the staffing to simultaneously review every rule on the books, then the petitioner could immediately go to the U.S. Court of Appeals and file an appeal on the agency's decision not to open up an old rule. While some of the provisions of the regulatory reform legislation that are criticized as grinding things to a halt wouldn't really, in my opinion, I think this particular way of looking back at old rules certainly has that potential, and I'm very concerned about it and couldn't support it for that reason. Having touched on what I think are the three major provisions, and having identified those respects in which my views differ from those of my panelists, I'll stop and turn the floor back open to them and to you. Thank you very much.
Thank you, Paul. It is the time now that we open the floor to questions and answers. There's a microphone to my left, one to my right, and there is, I think, I can't see, but there is supposedly one also in the balcony. I would like to first ask in our usual format, is there any former congressman that would like to ask a question?
Simply like to ask Mr. Smith, Mr. McCloskey, and Ms. Goldman to respond to Mr. Portney's point, which sounded terribly sensible to me, his 3 points.
All of his points? Let me just find your judicial review.
20 seconds or less. I mean, that's not.
I think I understand Paul's concern about getting more actors in the review process, but I think it's naive to assume that agencies that have evaded executive orders since the time of Carter, Ford, Reagan, Bush, and now Clinton, to carry out meaningful analysis of the implications, have still come forward with the same ideas, the same rules. Stephen Malloy has done a recent survey of EPA risk analysis, and if I can paraphrase, it's whatever answer EPA wants out of the analysis, EPA gets out of the analysis. NEPA has judicial review in it, and we've learned to live with the National Environmental Policy Act. It seems to me that it would be vastly better to have no risk bill at all than a risk bill that put the agencies back on their honor, when to date we know the incentives of the EPAs and the other regulatory agencies give them no reason to conduct the balance analysis that's the whole purpose of this exercise.
Paul said that we're just dealing here with a question of taking cost into account. I think in the case of the Dole bill, we're dealing with a lot more than that. The provision very clearly says that the benefits have to outweigh the potential costs. It's not just some sort of soft language. It's really hard, clear requirement. There also is a very critical difference between the Dole and the Roth bills in this matter. The Dole bill very clearly says that you've got to have a conventional favorable cost-benefit ratio, and it's got to extend to all the alternatives studied. And there are various requirements about what those alternatives should include. The Roth bill, on the other hand, has rather soft language that doesn't really crisply require that. And it's more like taking it into account rather than requiring a favorable cost-benefit determination. So it all depends which bill and which language finally prevails.
Lynn?
Well, a few things. I think on the first issue, where Paul, you said you felt we have a difference, I'm not sure that we do have a difference. I think that we would agree that the kinds of analyses that we do under the executive order, risk assessment and cost-benefit analysis, if that were enacted into statute, that we do that kind of analysis and incorporate that information in decision-making, I don't believe that any of the federal agencies would have a problem with that. But I think there is a real difference between doing those analyses to take that information into account versus doing those analyses to basically supplant those findings for the standards that are in law. And I just don't believe that those analyses are strong enough to be determinative of what our decision should be, nor do they encompass all of the factors that should go into a decision. So we may or may not have a disagreement on that point, because the way I read this legislation, it's not simply putting into law the president's executive order. It is actually changing how we make the decisions and limiting us to those factors in making decisions. In terms of the other issues, again, the look-back provision, there is not a problem with looking back at existing regulations. In fact, we're doing that today. President Clinton has asked us to look back at every rule page by page. The problem is the presumption in these laws that if you don't complete that look back, complete with a thorough risk assessment and cost-benefit analysis by a certain time, that the rules sunset, that they drop dead. And in our judgment, the workload for doing that is so substantial that a lot of laws and a lot of regulations and rules would simply drop dead without our ever having a chance to do those lengthy and thorough analyses, especially taking into account again that all of that is subject to judicial review. In the issue about judicial review, I couldn't agree more, and I actually think it's interesting that NEPA, the National Environmental Policy Act, was brought up, because I think that's a case in point where judicial review has led to lengthy analyses, huge, thick documents that are produced by consultants, which produce some degree of benefit, but it is not clear to me that all of the effort that goes into that exercise provides an environmental benefit. In fact, often it is not clear to me who reads those analyses. And so I would push back there and say, I think that NEPA is an example of how judicial review can be very dangerous in this kind of context, where a notion that started out as something that sounded very good in terms of promoting flexibility and the use of good science and environmental protection turned into an incredibly prescriptive process that has not produced the benefits that it should be producing.
Paul, do you want to respond?
But I'd love to, but there are a lot of people at the microphones, and,
Okay.
and let's give them
All
a
right.
shot.
Mickey, wherever Mickey went, right there. Oh, okay. All right. Please state your name and your affiliation.
Hi, I'm Janelle Schmidt. I'm a graduate student here. I have a question for Mr. Smith. You recognized in building your argument against regulation the tragedy of the commons that can lead to misuse of resources. It seems to me that there are some resources that can't be parsed out to individuals, like air and water. And I'm curious to know what you think is the ideal way to prevent the tragedy of the commons from destroying our air and water.
Yeah, the issue, the argument that property is essentially divided up by God or something into commons properties and privatized properties seems to me to miss the evolutionary potentiality of taking property that at one stage of institutional arrangements, at one stage of technological fencing and monitoring technologies is hard to privatize, and to recognize that over time we have a better ability to build more creative fences. The whole history, in a sense, of Western resources, of resources in the modern world, has been an increasing ability to fence off complex resources. Underground oil reserves are treated as private property. Underground aquifers are treated as commons. We're beginning to learn how to privatize the oceans. We just did a book called The True State of the Planet, in which we looked at institutional ways in which we could begin to move towards the complex task of privatizing the oceans. Privatizing the airsheds is going to take a while, but that's the only way we're ever going to get serious about these issues.
So you don't think that there's a role for regulation, that perhaps there are some things that can never be parsed out to
I think the
individuals?
challenge is to find those boundary lines. At any one time, there'll be some resources left out in the cold. I think the challenge of those people who, if there's anyone seriously interested about the environment, is to try to find creative ways of bringing those resources into a system of meaningful management. Commons are going to be mismanaged. There are creative ways of beginning to privatize commons, and we ought to be thinking about that. And a system of private stewardship mobilizes the entrepreneurial forces that make it possible over time to manage that. We couldn't own the western lands at one time. We had these gigantic acreages of environmental resources, pasture lands, and we had no technologies that allowed us to monitor those from the pollutants, the cows that eat up my grass. What we found, though, is by having a system of private property that forced us to do the best we could, use cowboys, in a world of wage rates going up, cowboys got too expensive, and creative people outside of that environment created barbed wire, which made it possible for us to privatize those commons and do a better job of managing that environmental resource. What the barbed wire equivalents are likely to be for groundwater, rivers, lakes, and so on, it's not at all clear. But that's the challenge, I think, that serious environmental policy should be moving to. That's what Coase argues, incidentally, if you've ever read him.
Hi, I'm Doug Copeland with Industrial Economics, an environmental consulting firm. My question is also for Mr. Smith. You mentioned quite a bit about the power of markets to help solve environmental problems, and I was wondering if you are also at the forefront of efforts to repeal the billions of dollars in subsidies that go to timber, irrigation, energy, and mining every year.
Yes, we are. We've been, those of you know the conservative public interest movement, if you can call ourselves that. There are a lot of variants in this area, and in many areas, I think Mike and I was talking about earlier, the environmental movement, the environmental establishment, the traditional environmental movement and the modern environmental movement, I think in many ways share a concern about the distorting effects of corporate subsidies of various types. The agricultural subsidies encourage very intensive use of land, and those have created situations where we're essentially over-exploiting certain parts of the soil. I think those areas are, well, as we talked about ethanol, I mean, there are many, many areas where we're essentially subsidizing the destruction of the environment, World Bank and a lot of other cases like that. Those are areas that ought to go very quickly, and I think there's a growing consensus. Senator Lugar, who's running for president from a farm state, has announced his plan to eliminate the farm subsidy programs. Some Democrats might be in favor of that too, but it hasn't been, at the moment, a very vigorous bipartisan effort to eliminate these things.
Thank you. Is there anyone upstairs? Oh, if not,
My name is Jonathan Clement with MIT's Technology and Policy Program. After having spent a year as a contractor to the EPA performing risk assessments for the dioxin in the pulp and paper industry, I have a kind of a sense of what we're in for if this cost-benefit regulation goes through. I actually quit. I quit after a year just out of disgust, mostly because the models aren't particularly complicated. They depend completely upon the parameters which are selected, and I'm concerned about where we're going. But the questions I actually have are for both Mr. Smith and Mr. McCloskey, and that is, in your statements, I didn't really hear anyone addressing the issues that either side seems to be concerned about. Mr. McCloskey, in reading Sierra Magazine, for example, I see references to Joe Sixpack and other slightly derogatory references to private property owners or people who are more or less concerned with issues of liberty and other things that are part of the political vocabulary today. And I'd be interested in hearing you address, kind of from their side, what are some of the either concessions or some of the negotiating territory that you might have. Mr. Smith, I'd be interested in hearing you address issues of market imperfections, especially if you believe that private property owners are capable of dealing with these issues, things that economists talk about, for example, asymmetry of information or issues of relative informedness, how can markets, I mean, not to say that I mean, governments aren't perfect and markets aren't perfect. I'm interested in hearing how you feel that those market imperfections will be dealt with.
The essence of your question, as I got it, deals with negotiating territory. On the issue of takings, I tried to briefly address that. I think it deals with putting more emphasis on financial incentives for landowners to help with the protection of endangered species habitat or for the maintenance of wetlands of certain character, perhaps where there's greater debate about the historic nature of them as wetlands. It may be that the sheer controversial nature of some of the reach of regulatory programs on land may drive us toward that direction, and I don't think we have a problem with inventing something in that territory. In the area of regulation, this is a complicated question, but I'm participating, as many others are, in some of the negotiations in the President's Council on Sustainable Development. I must admit I'm more of a hardliner, but even there we're beginning to outline some criteria for experimentation with substituting performance-based standards for technology-based ones, where that would go beyond compliance requirements and where constituencies would be bought into differential effects and impacts, and where we would experiment with it, where it would be reserved for good performers. There are some other things, too, that are being talked about there. I don't think these are without problems, because technology-oriented standards really are committed to continuous improvements, and performance-based ones aren't necessarily. But it's an area we can talk about.
The question you ask about comparative institutional analysis is a very important one. It's the whole basis of Ronald Coase's work, and it's not an easy one to answer in any short question. We've written a lot about this, and afterwards maybe we can talk about this, but generally the question is, what array of voluntary arrangements, market and other non-market arrangements, versus what array of political institutions might be useful in an area? And there one looks at market failure and government failures in the various ways. But I would argue that in many cases, the examination of ways in which market processes or voluntary arrangements have moved to resolve what are called market failures has been underappreciated by sort of the technocratic planning community. On the property rights issue, just quickly, we have got a very large involvement in the Endangered Species Act. Our people are trying to find creative ways of look, if you listen to E.O. Wilson, one of your professors, there's 10 million species in the earth that are there, that we would like to have continue into the future. There's, 184 governments, and if you read your papers every day, you find very few of them are protecting their human populations. The idea that governments are going to be the only way to protect 10 million of anything is fanciful. There are 5.5 billion people on this earth. If we can begin to create ways in which people can domesticate these species, we move towards a situation of potentially realistic ways of helping species. The biblical tradition, Noah would go to jail if he tried to load his ark up with species today. We've made it harder to save species in the past because, in a sense, we tell people that if you find rare metals on your property, you're better off. If you find a rare artwork on your property, you're better off. But if you find a rare species on your property, it may not be your property anymore. People in the South are going out or hiring people to chop down habitat trees for red-cockaded woodpeckers because they can't take the risk that their property may be seized under the ESA laws. We are turning people into enemies of nature under the guise of protecting nature. The Endangered Species Act, in my opinion, is endangering species and certainly needs to be rethought.
Paul, you want to comment?
Henry, thank you. If I could briefly, this young fella asked part of a question that I think didn't get satisfactorily addressed here when he asked Mike about Joe Sixpack, and it just prompts me to make one observation about regulation and why I think it's important that we ask regulatory agencies to take cost into account and try to only put in place regulations that do more harm than good. And that's the fact that in looking across regulatory agencies in Washington, and in fact looking at people in this room with the possible exception of you students, no one who writes regulations and no one who listens to debates like this at the end of the month will worry about whether or not they'll have enough money to make a mortgage or a rent payment, buy a bag of groceries for their family, or buy medicine for their kids or for their parents. But there are a lot of people out there in that position. We just don't see them very often in Washington. And for that reason, if for no other reason alone, I think it's important to ask people in regulatory agencies to take into account as one factor in setting standards, how much is this going to cost, and to ask them to justify new regulations, and in fact existing regulations through look back, on the basis that, all things considered, qualitatively and quantitatively, this does more good than harm. I don't think there's anything wrong with that.
Lynn?
Yeah, I think I need to add to this because I actually think that the bills that are going through Congress have very little to do with the concerns of the folks who are having trouble making ends meet, buying their groceries, and so forth. Very little to do with their concerns. You know, those folks, the last thing that they want is to have to worry not only about that, but whether it's safe to drink their water, breathe their air, live in their communities. And I think that the one free good that we should all feel entitled to is a safe and healthful environment. The folks who are concerned, and I think legitimately so, and I think that who we need to address are especially the small business community in our society and local governments. Those are the people who have been impacted by a layering on of regulations that sometimes does not make sense, sometimes has imposed burdens that are excessive. And as strongly as I believe in environmental protection, I have also seen a lot of cases of this at the agency, and it's been inevitable that over the past 25 years that some of this would have occurred. The answer is not to roll back our standards and provide less protection for people in this country. The answer is to go back in and fix these problems with our regulatory system, remove unnecessary burdens, make our system work better for people.
My name is Nick Gertler. I'm a graduate student in MIT's Technology and Policy program. I'd like to revisit 2 points Mr. Smith made in his opening remarks. The first one, you said that the problem is not that EPA is doing wise things foolishly, but that they're doing foolish things. You then mentioned a list of areas ostensibly EPA is concerned with. Could you please repeat that so we could specifically identify the ones that are
And
foolish?
I forgot Superfund, the poster child of environmental reform, which I think all of us agree ought to be reformed. The ones I mentioned were, well, the standard list of misprioritized risk.
Well, you mentioned cancer and radon and chlorine, if I do recall. I mean,
Dioxin, there were substances. Dioxin, radon, chipping lead paint. And then in the area of the various endangered species list, spotted owls, so forth.
So it is correct to assume that what you are saying is that, say, radon, lead paint, and dioxin are kind of foolish issues to address.
Let me give you lead paint because this gets into Lynn's question, I think, quite well. I testified on this before the Appropriations Committee on Environmental Issues, and the issue of lead paint. And we all know that lead, like many heavy metals, is a toxic substance, and if ingested in quantities, especially by children, can create neurological and other problems. The remediation standards for this that are required that we go in, and Cambridge has this, that we go in and ensure that there's sealed, that we've sealed all the paint, or in some cases totally removed it. Well, it sounds like a very sensible idea if you don't take any consideration of what the consequences are of such regulations. The areas of America that have chipping lead paint are not the areas we live in. They're areas of inner city America where poor people live. These are areas that have many things in their home besides chipping lead paint that children shouldn't put in their mouth. Roaches, razor blades, hypodermic needles, sometimes guns. These are things that are very, very dangerous. These are serious problems in the real world. People face real risk in the real world. When we go after parts per 1 in a million risk, when people are dying of 1 in 100 and 1 in 1,000 risk, we are trivializing the plight of people who aren't at these forums, are not here. These are people who basically are living lives of desperation. And we go into those people and say the most important thing to you, because we worry about it, is chipping lead paint, and we're going to force remediation mediation at $30,000, $40,000, $50,000 per unit in home stocks that are not worth anything like that, we tear those homes down. Living in a home with lead paint's a risk factor. Living on the street's a much bigger risk factor, and that's the kind of policies that are bearing on the poor today. Superfund has made it impossible to develop brownfields throughout inner city America, where job opportunities and wealthier is healthier, and having a job is a health factor. Superfund and a lot of other factors have a direct effect on the economic ability of individuals to have a better life. One of those factors is a better environment, as Lynn's concerned about, as all of us are. But the environment of humans is more than just the physical environment. It's also the economic environment in which they live, and we shouldn't trivialize that factor.
Wait, we don't have time for multiple questions. I'm sorry. Yes.
Yeah, I'd like to address something which hasn't been brought up. My name is Dr. Edward Siegel. I'm not a Harvard person. I'm not an attorney. I'm not a politician. I happen to be an original whistleblower from Westinghouse from way back. I worked at Hanford and Idaho Falls and Bettis, and I have terminal radiation poisoning. What hasn't been addressed is the nuclear problem. Now, I'll list two issues, and I'd like any response. Issue one is Henry Kendall's talk at MIT. I quote him, "I thought I knew something about radiation, being a Nobel Prize winner, until I went to Idaho Falls and Hanford. Barrels like peas in Stop and Shop, 30 high to the horizon, filled with plutonium salts, some with hydrogen in them, some criticality. And Westinghouse didn't even take the simple precaution of listing what's in which barrel. They don't dare touch them, and most of them are corroding. These are cheap ferritic steel barrels like what you put oil in. No way to clean it up. He estimated 350 to 500 billion until 2070. I worked there. I'd say perhaps $5 trillion until about the year 2500. Already they're finding radioactive potatoes in Idaho. He says half of Washington is irretrievably polluted. We're talking about 10,000 years. Rome didn't exist. The Third Reich wouldn't have existed that long. Okay, that's one issue. And by the way, what I'd like to focus you on
question, sir?
Yes. I want to list the second area, the need for retroactivity in going after people who've done long-term pollution in the past, and the specific criminals are the Westinghouse Corporation and the Cabot Corporation. And I'm the plaintiff in the large lawsuit you'll be hearing about. Second issue is nuclear reactors. You may or may not know the NRC is shutting down 70 right now, with the same problems as Maine Yankee. I'm sure you all read the papers about a month ago. And the new chairwoman of the NRC, appointed and approved by the Senate by your boss, Dr. Goldman, is on 5 utility boards. That's like asking Adolf Hitler to monitor the Nuremberg trials because he had prior experience.
I need a question here.
Question is retroactivity of blame, criminal as well as civil penalties, corporate and individual. And I'm the person with the evidence.
Okay. All right, that's the question. Anyone have an answer?
Well,
No laughing matter.
without knowing the specifics, absolutely not. Without knowing the specifics of the problem, to address the question in general, I think first that the principle of retroactive liability for environmental contamination, whether nuclear or non-nuclear, needs to be maintained. It is one of the most critical issues today in the Superfund debate, and the Clinton administration continues to stand behind that principle. It's really the principle of polluter pays.
Why is Westinghouse one of your prime contractors? EPA.
Again, I cannot really address the specifics of the situation. I just don't know anything about the situation that you are raising. And in terms of, again, the issue of enforcement, in principle, I have to agree with what you're saying, that environmental crimes need to be aggressively investigated and prosecuted. Again, without knowing the specifics, I just can't comment on your individual case.
Well, I think we should say something about the kind of liability rules we've allowed to grow up in this. And we talk glibly about polluter pays principle. And then we go back and hold people responsible for 5, 10, 15 years ago without even considering the standards or the goals of the time or anything else, or whether they were acting in full compliance with rules. Retroactive certainly should take those into account. I think it ought to go. It's a way of basically finding people way back in time who still have money in their pocket to do silly things like Superfund cleanups. We have joint and several liability that essentially is creating a travesty of polluter pays. We have a scene of the crime liability at Superfund sites in America. If you had money in your pocket and you're close to a Superfund site, you're going to be dragged into the process and be a PRP, potentially responsible party. This has done great violence to the whole concept of encouraging people to think carefully about, look, if I do something stupid today or criminal today, I'm going to be held reliable. Now everybody's criminal in our society. That's one of the reasons America revolted at the polls last year.
We're running out of time, so what I'd like to do is have two final questions. One here, and then if Mickey would like to ask a final question. And then give each of the panelists a 45-second final remark.
I'm Chris Bowman, Environmental Neiman Fellow on campus and a reporter with the Sacramento Bee. I have a question concerning public perception of risk, which any of you can take up. It's been shown that there's a rather large difference between the way EPA scientists and insiders and analysts rank environmental threats and what's of utmost public importance, and the way the public itself ranks those risks, for example, on pesticides. And it's been shown, and it's been, the press has been criticized for that gap because of its failure to report adequately on the scientific elements and uncertainties surrounding these issues, and I think the criticism is probably well-deserved. But I want to hear what you think about press coverage on issues of environmental risk.
Press coverage has been abysmal. It's been almost criminally irresponsible in its attempt to essentially trivialize and distort the scientific record. It has sought to highlight the most extremist positions. It has never sought balance to date. It's getting better. The Society of Environmental Journalists has been an organization that to date has only begun to recognize. Their first session they had Warren Brooks, who some of you know was a journalist, I think, beginning to try to bring light. He's dead now. We formed the Warren Brooks Fellowship Program, and we now have had our third Warren Brooks Journalist Fellow. And I think we're beginning to get something. Keith Schneider, basically the New York Times environmental reporter, eventually was edged out of the New York Times when he started saying maybe the best thing you could do with Superfund sites is to seal it up and put a fence around it and say don't dig it up. I mean, it looks like by the time the environmental reporter gets to the point where he's recognized how to take a balanced view, he's tired of the issue and goes away. I hope you don't. I don't know where you are in this process right now. But the journalist tradition here has been very bad. It's getting somewhat better, but it's just so easy to hysterialize in this area, and they've done it.
Mincing your words again, Fred.
Yeah.
Anyone else want to say something?
Go ahead. Well, I have a somewhat different take on that question, though I am unhappy with people like Keith Schneider, because I think there has been in the last couple of years a tendency in the press to think they've got to find some mathematical middle ground on issues regardless of the merits. And if the environmentalists are here and Fred and his folks are over there, it isn't a question of whose arguments are better or who has the facts or the science to support them. It's that find a middle ground and don't believe either side and don't follow the facts. And I think we've gotten into kind of a never-never land of debunking going on without any real inquiry as to where the better arguments and the facts lie.
Mickey? Lynn, you want to say something?
Well, just one comment. I've worked a lot with the press in this business of environmental protection, and I think members of the press are human beings like any other group of human beings, and most of them try to do a really good job. They have varying degrees of sophistication about issues, and it is true that some of the issues we deal with in environmental protection can be very complex, very difficult to understand, very difficult to convey to the public. And I basically have a lot of respect for them because I think that most of them do a fairly good job given the complexity of the issues and the real difficulty in explaining many of those issues to the public.
Mickey?
Yeah, I'm Mickey Edwards. I'm on the faculty here, and I teach a course in conservative politics. And the final paper that I've asked my students, many of whom are here tonight, to address is to look at how a person who understands and respects conservative political principles would address environmental issues. I'm not quite sure what they're thinking at the moment. I think that leaving Dr. Goldman and Mr. Portney aside, one of the things I heard in response, what I heard from the panel before the question that was asked over here about where is there common ground, and what I heard afterwards, at least with Mr. Smith and Mr. McCloskey, is there doesn't seem to be very much. And what I heard a lot of words from both of you about catastrophic, cataclysmic, and all kinds of things referring to the other, and what would happen if any of the other person's views got taken into account. I'd like you to readdress, at least the two of you, the question that was asked earlier. Asked Mr. Smith, is there an area in which you believe, consistent with your principles, it is possible to take communal action as a society, not just individually, and not trying to domesticate tigers, where it is possible to address real, valid environmental concerns. And I would like to, and for example, does cost benefit have a limit? Is there a place where other values transcend the cost, where the benefit is non-economic? And I'd ask Mr. McCloskey, who seems to be rather critical of Senator Dole's proposal and others, is there no place for measuring cost? Is there no place in which the Sierra Club and other environmental groups might take greater concern about what Joe Sixpack is concerned about and jobs and so forth? Is there any place for you all to find common ground?
I think when the public opinion surveys have consistently shown a great majority of the American people want strong environmental protection, and that continues right up to the moment, that has to include a lot of Joe Sixpacks. So I don't think this is an elitist interest, and clearly everybody has benefited from cleaner air and cleaner water and less risk. As to the question of cost, yes, take it into account. It is a legitimate question and concern. And I agree that on small businessmen, we probably have to rethink how to ease their way into doing what they should for the environment. I believe in assessing risk. Basically, it's simply seeing how severe and likely various threats are. It's a question of how you do it and how much emphasis you place on it. And the same goes for assessing costs in relationship to benefits. But a lot is not quantifiable, and where you can quantify things, the figures are often not robust, and there are unknowns and always emerging in these matters, and it's more an art than a science. And I think it's a disservice to rationality to pretend that these are all technocratic exercises, little black box machines where you feed in the data on one end and crank out a public policy answer on the other hand. And that's what we're facing in Washington now. I think perfecting these tools, taking them into account, trying to develop better tools is what we should be doing.
I think that's a very important question, and I'd say yes and no in a sense. The first generation environmental policies where we were addressing a handful of big haystack pollutants from a few major sites, we had a simple consensus. I think it was possible to have a consensus view there. We all knew we wanted to do those first steps. But as those first steps have now been played out and we've achieved those goals, we're now into thousands of minor needle pollutants at literally millions of sites throughout the country. I think we're trying to save every species in the world, or which one's first? Do we go after dioxins in the Hudson, or do we go after urban air pollution in Phoenix, or the thousands and millions of other priorities? I think in that area consensus is broken down. What do we do to create a way of us, each one advancing those values that we care deeply about in the environmental area? I think there's a tremendous idea that America invented in this area. It's separation of church and state. religious values are not just about God, they're also about the kind of nature we believe we ought to see. We have our different perspectives. Some of us are Bugs and Bunny people, some of us are clean air people, some of us are coastal management people. Why don't we begin to create an idea of beginning to move the dispute out of the political world where consensus, however achievable, is necessary, into sub-regimes where we don't depreciate the values of environmental issues, we just allow each person to advance them individually. The cathedrals of God are not advanced in the United States politically. We let each person use their money, their properties, and their hopes to build the temples they believe in and protect them privately. I think the cathedrals of nature are wonderful, but I think it's time for the people who are richer than the average person to pay for the kind of cathedrals of nature they care about and move this conflict out of beggar thy neighbor, let's all get mad at each other policies. I think there's a tremendous chance for institutional agreement about moving at least some of these areas out of the political regime and into the private regime and minimizing the conflict potential, which I see as headed towards eco-wars otherwise.
Time is late, and I would like this time to ask for summation statements, and since I think that both Mike and Fred have given, I think, that answers pretty much a very good summation statement of their positions, I'd like to ask Paul and Lynn to give take a minute to give their summation.
Yeah, I think that the way to move forward is to not try to return to policies of the past that were failures. I think the way to move forward is not to try to enact legislation that's basically ideologically based legislation. Unfortunately, what's needed is an approach that requires a lot more effort, but I think will yield a lot more benefits. At the agency today, we have an initiative underway called the Common Sense Initiative, where we're working with a number of sectors individually and looking at all of the laws and regulations that affect that sector. I chair a work group that is with the computer and electronics industry. And in those discussions, we can see the places where our laws and regulations make sense, the places where they don't make sense, the places where at times we even impede some activities that would be beneficial, like recycling. That's the way that you identify the problems, what's broken, what needs to be fixed, and that is the kind of approach that needs to be undertaken. I think that we need to undertake such approaches with small business. We've made a pledge, kind of a promise, to decrease the reporting burden for small business, but we need to find out how to best do that, because I think part of what's happened is that a piling on of our regulations that is not noticed by a large corporation can be very meaningful, very expensive for a smaller company. These problems need to be addressed in a way that involves consensus building, where you have people who are concerned about the health of the businesses, people who are concerned about the health of the environment, people who are concerned about communities and labor involved. It should not be done simply by the business interests and the regulated community writing their own ticket for reform, and unfortunately that's what we see in Congress today.
Paul?
I'll be very pedestrian in my final remarks here. I guess I want to go use part of my time to address Congressman Edwards' question. It seems to me that I can briefly tick off 3 areas where I think there is the potential for significant common ground between people in the environmental community and people who are conservative or libertarian in their views. First of all, it seems to me that there is by now almost unanimous agreement that where you've decided to do something to protect environments or natural resources, wherever possible, use markets or other decentralized approaches to do it, rather than specific top-down command and control. And I think that's something that people in the environmental community now support, and that the notion of using markets, and in some cases, even private property rights, are a way that we can do this. Second, and Mike McCloskey's comments, I think, give witness to this fact, I think there's now uniform agreement among people in the environmental community and true libertarians or conservatives that costs are one of the things that ought to make a difference in writing regulations and making decisions about natural resources. There will be disagreements about the way we take them into account and the weight that they should be given, but everybody by now agrees on that. And looking back and taking the 25-year perspective that Lynn raised in her opening remarks, it wasn't like that 25 years ago. The idea of even taking cost into account and setting an air quality standard or deciding how much of a forested area we're going to protect was heresy. We're beyond that now, and I think that's encouraging. And finally, we've heard broad agreement on the panel tonight that in those areas where federal subsidies have adverse effects on environmental programs, we ought to eliminate them. We'll reduce the budget deficit, and we'll stop harming forests and other kinds of agricultural lands, resources, etc. So eliminate subsidies that cost you money and harm the environment. Those are three areas where I think we can make progress. I guess in conclusion, I would just say that I think in some respects we've got a great opportunity to put in place a regulatory reform program that can really make a constructive difference. The question is, will we screw it up just like we do every time there's an opportunity to change something by going too far from the direction that we're currently in? And I think that risk is there. It's very great. It's a risk that Mike and Lynn, I think, are more concerned about than I am. I tend to see my glasses all the way empty rather than not at all full. So I hope that we can sort of retain the best elements of what's being discussed now, because I believe that there are good elements being discussed, and jettison the stuff that really does have the potential to make things worse. Thank you very much, Henry.
I would like to thank you all for coming this evening. Our goal was to join the debate. I think we more than accomplished this, and I'd like to ask you all to join me in thanking our panel members.
Hi, Guy. How you doing?
Love turning Mark about the Chris.
Exactly right.
Thank you.
All of you guys.
Right.
And then if one starts
How do I respond?
well, right, how do you best if there's